Hi everyone, I'm Prosecutor Pete Lucido and I'm here today with Kumar Palapu, and he is our Chief of District Courts.
Once the person is arrested for their crime, the first step is arraignment on the warrant. And at that point in time, a number of discussions are had between the defense attorney, the judge, and us.
We're there on behalf of the people to make sure that the bond is set appropriately, and we request this of the judge. The judge doesn't necessarily have to follow it. Explain that.
There are a number of factors that are discussed about a person and what their bond should be set. It's do they have a criminal history, the facts of the current case and the crimes. Also, have they ever had any non-reporting for a court case they've had in the past, and do they have family support and maybe what their occupation is. Depending on all of those factors, someone could maybe just get personal bond.
Correct.
And but also depending on if they have a criminal history or the facts of the case are just so severe, the judge could decide that they need to set something to make sure that that person is going to come back to court if they are released, and possibly set a bond that is pretty high in order to make sure that society is protected.
If the crime is violent, such as, running from the police, going 100 miles an hour plus down the street, putting life as well as property at risk, or there's a gun involved or a weapon involved, what happens then?
Well, there's an argument to be made that if someone ran from police, then they may run from the court system in the future. And if there's a gun involved, it's often the question on what is their mental health, why were they running, are they going to be a threat in the future? And we want to make sure that that person is held responsible for the crimes, but also society is protected in case that person may not be acting logically in society.
When the bond is imposed by a judge, what kind of conditions can a judge put on the individual if they're going to release them?
Well, depending on some of the things that they might be concerned about, there could be a no contact order if there was a victim, let's say in a domestic violence case. Someone may need, if they were driving under the influence, they may need an alcohol tether or a sober link for their vehicle, or they may just say that they need to start AA to get a handle on that.
There could be other things such as mental health counseling or outpatient counseling of any nature, any kind. And lastly, there can be wearing of a tether so that the court can keep track of where they're at and where they're supposed to be, so that they don't have a risk of harm to society, and or, like you said, a no contact order, that they're not going to be around the victim. But the judge has to almost ensure the society is protected one way or the other when these conditions of bond are set.
And that's always our goal. We want to make sure that the person is clean and sober while they're out, so that they don't do more things they shouldn't do.
Correct.
And that our victims are safe and society safe.
Well, let's keep it a safe society, because that's what we're here. We're here to ensure that justice is not only provided, but also that the victims are served in this community and that the community remains extremely safe.
Well, we have 16 assistant prosecutors that are assigned to every single one of those district court programs. They go to the courts, they handle the cases that come through those courts. Those cases could be anything from a sexual assault to an armed robbery to financial crimes, domestic violence cases. They are assigned a docket, they take their files, they go to court, they meet with the defense attorneys, and they prosecute the cases. They're there for the hearings.
Thanks for all your hard work, your dedication, and thanks for your service too as a member of the Armed Forces.
Thanks, Pete.
Have a great day.